各位朋友，大家好。现在已经是早上9点。那所以说早起的鸟儿有虫吃。我想今天呢，大家的听众会在这次的这个线上研讨会会有所收获。如标题所示，我们今天的题目是美国2022年最新专利实务发展以及台湾专利相关实务的比较。这一次的这个线上研讨会呢，大致可区分为4个部分，也就是从 Topic 1到 Topic 4。那在第1和第3个部分呢，会是由我们美国的讲者Juan先生来去做介绍。那第2跟第4是针对同一个案例，但是针对不同的这个争点来去做分析跟比较。首先呢，现在必须说明一下，就是因为本次的研讨会呢，我们是没有收取任何费用，然后目的是属于一个教育性质，所以这次研讨会呢，不涉及任何关于法律上面的建议。那也是希望各位听众可以在这次的线上研讨会能够得到所有的收获。那我们也尽力使这个所提供的资讯呢，尽量的正确与完整，但是呢，不能够做到完全的这个保证。这边是一个例行性的这个 disclaimer， 先跟各位说明一下。那在接下来呢，我先介绍一下这个我们美国的讲者Mr. Juan Carlos Marquez。Juan 呢，我跟他就是已经认识了超过10年的时间哈，所以就是我们彼此很熟。那我在这个过程中，我就直接称他的名字Juan。那Juan在这个IP 的业界，在美国 IP 业界，特别是专利跟商标的部分呢，已经服务超过30年。那Juan他的特色就是相较于其他的这个美国律师，他们有一些来台湾有做一些演讲等等的是Juan他拜访亚洲的次数呢是非常频繁，他经常来到台湾、大陆、韩国跟日本这几个地区。然后针对这边的客户呢，他会做一些这个彼此的交流，还做一些学术性的研讨等等。那他也非常了解亚洲这个就是客户的一些需求啊，特别他在这个专利说明书撰写啦，还有在关于这一些专利诉讼的准备等等呢，有非常丰富的经验。我相信今天的研讨，他会给大家带来非常多的一个帮助。那接下来介绍的是我自己部分，名字叫孙宝成，我在履历服务了17年，那在专利这个行业超过20年的这个经验。那我这边稍微介绍一下，就是我是台湾的专利师，所以如果各位听众是台湾专利师的话，也许在专利师公会这边我们有碰过面。那我自己也是在美国那边呢，念书念了3年，得了这个 JD Joint MIB 的学位。听众里面也许有我们的学长或学弟，或是学妹学姐在这边。我后来在那边是取得了纽约州还有这个麻州的律师资格。过去几年也取得了中国律师的资格。所以基本上我自己的承办的业务是以台湾案跟大陆案比较多，但是也有服务台湾的客户到国外去申请，特别是美国的部分，还有处理一些美国方面的这个专利的争议的分析，还有一些建议等等。它这个 PPT 呢的这个PDF 档，我们在昨天已经提供给各位了，在上面你们都可以看到Juan跟我的这个联络方式哈，如果有需要的话可以跟我们联络。当然问题不限于今天所讨论的题目。接下来我先大概把这个整个会议的架构跟各位有所介绍，让大家也有一些准备这样子。在今天的开场9点10分完结以后呢，第1场这个 Topic 1呢是针对的美国的这个subject matter 的部分，它是不是一个合法的 subject matter eligibility。那这部分呢，在美国的这个实务上是非常的火热哈，特别是关于这个软体还有一些生物类的部分。那 在前一阵子美国的这个实务做修改以后呢，在101的这个条款部分呢，对申请人产生了蛮大的影响，特别是针对一些如果是属于这个法定的这个抽象的概念等等，所谓他们被分类到一些特殊的类别的时候呢，会被严格的检视它是不是这个法定适格的标的。那放在这部分呢，会提供相关案例的介绍，也会告诉各位说，在美国的这个NPEP 那边呢，他们也做了一些修改，然后会给各位一些指引，怎么样在撰写专利说明书的时候呢，去尽量避免这个碰到这个subject matter 的问题，因为一旦 subject matter 问题没办法克服，后面的新颖性啊，还有这个非显而易知性的问题，就甚至都不用考验，因为你根本就不符合的专利标的。那在接下来的第二个部分呢，是我这边来向各位介绍一个案件呢，就是 Quantity 这个案件，它就是相关于这个现在最热门的无人车驾驶技术的一个案例。那这个案例里面有2个争点，一个是怎么样去做最宽广合理的请求项解释，还有第二个争点是关于辅助性判断，这是在第4个这个部分呢，Article 4的部分由我来负责。那第3个部分是关于这个美国的 Article 3，从10点10分开始，会由Juan来向各位介绍。那Juan这边他会告诉各位这个美国设计专利最新的实务可能设计专利它的用处比各位想象的来得大。其实不管是美国部分，台湾大陆也是一样哦。那它的这个有效性维持率在美国是非常高的，而且在他介绍案例里面，你会之后会听到关于这个三星跟苹果的案件，那个损赔的金额非常的高，而且相对来讲，设计专利的这个申请费用跟后续的费用也相对的低，其实是有它的用处。那Juan会提供相关的一些他的经验和一些建议给各位。由于时间已经到了，我想我就现在把这个就是话语的这个控制权交给Juan。Juan, now it's your time, so I will switch the control to you. Okay, please.
For those of you that my colleague Lillian, you and I have visited in prior years, it's very nice to be with you again and a chance to see all of you and to share information with you again. For those of you we have not yet met, thank you very much. We are honored to have you and to have you join us. Today I would like to discuss just a couple of topics that I hope will give all of you some good information and hopefully some updated information on some issues that are occurring in U.S. patent practice. The first topic we will be discussing is the issue of subject matter eligibility. And I say that these are current trends in protecting software, algorithms, and other unconventional inventions, because the subject matter eligibility issue only comes up in those very unusual, when I say unusual types of inventions, because they are usually software or some kind of process that is implemented only on a computer or on the internet or on a computer network, or maybe inventions that are based around some kind of mathematical formula, some mathematical algorithm, or some, in cases, laws of nature. So, in this area, we will discuss 3 things. 1, basically subject matter eligibility in practice in the United States. 2, we will then discuss some practice tips and strategies to help you in prosecuting applications for clients in the United States. And we will also try to draw some conclusions based on our discussion. So what is the current state of a subject matter eligibility or Section 101 case law in the U.S.? Well, starting from the beginning, much of what is now done in the U.S. under Section 101 is according to the U.S. Supreme Court's decision in the case of Alice versus CLS Bank. In that case, and because of that case and recent decisions by the Court of Appeals for the Federal Circuit, there is quite a bit of uncertainty there as to what technologies are eligible as patentable subject matter. There is at times confusion because of some of the decisions that have occurred since the Supreme Court. Specifically with the Court of Appeals for the Federal Circuit, or what is known as the CFC, or the Federal Circuit for short. The Supreme Court is the one who came up with a very short test in the Alice case. And since then, the Federal Circuit has been the court that has had the most responsibility in trying to interpret that test and trying to apply it in the different cases, both at the litigation level and at the level of prosecuting patent applications at the U.S. Patent and Trademark Office. The situation is very uncertain, and in many cases, it is felt that there is no clear direction as to what is patentable subject matter and what isn't. Even in a previous case called U versus Apple, one of the main patent judges, very well known for her experience in patent law, Judge Pauline Newman, expressed an opinion that in the current state of Section 101 jurisprudence, inconsistency and unpredictability of adjudication have destabilized technological developments in important fields of comments. She's basically saying because of the way the Federal Circuit has interpreted Section 101 in light of the Supreme Court's Alice decision, there's a lot of confusion.
You have to open your PowerPoint slide.
Is it?
Your PowerPoint slide. Thank you.
Is it open now?
Yes.
Oh, sorry. Okay. My apologies. Okay. So, continuing, let's do a quick review as to the current tests that are actually being applied in the U.S. Now, as I said, the Supreme Court of the United States was where the test under Alice was first created. The Supreme Court came up with a two-part test. Okay? Part one, you are supposed to determine whether a claim in the patent is directed to an abstract idea. What is an abstract idea? An abstract idea is by definition, is some kind of fundamental economic practice, a method of organizing human activity, is just some kind of idea in itself, or a mathematical relationship or formula. Okay. Now, the Supreme Court said that an invention is not necessarily barred from not allowed to become patented if it involves one of these abstract concepts. Rather, under Part 2 of its test, the Supreme Court said that if an abstract idea is present in a claim, you have to determine whether any element or combination of elements in the claim is sufficient or enough to ensure that the claim amounts to significantly more than the abstract idea itself. The important part of this sentence are the words significantly more. The Supreme Court did not explain what they meant by those words. And that is what the district courts and the Federal Circuit have struggled for quite some time, trying to give some clear definition. there are some examples of what is significantly more, what could be significantly more to make a claim patentable. Okay? Some limitations you could put into a claim would be improvements to a technology or a technical field, such as computers, electronics, or materials, or improvements to the functioning of a computer. It makes the computer more efficient, faster, have more processing capability, or be able to accomplish a function that a computer could not do before. Other limitations or other examples of limitations are things that generally link the abstract idea to a particular technological environment. Mostly, in the cases in the United States, they have been computer-related, software-related, or related to working on a network. Now, some examples of what limitations are not enough to help make a claim patentable are words in the claims that say apply, or just using a generic computer to perform the functions or the steps in the claim. Now, the U.S. Patent and Trademark Office, because they are the agency responsible for patenting or allowing inventions to become patentable, has also developed their own guidelines on how they would examine a patent application to determine if it has a subject matter eligibility problem. They took basically what was the Supreme Court Alice test and some of the findings and decisions of the Federal Circuit and put them into guidelines that they gave to their examiners. And there is a multi-part test that they apply. Under the USPTO subject matter eligibility guidance, step 1, just like step 1 of the Alice test, an examiner is supposed to determine whether the claim or the subject matter in the claim falls within one of 4 statutory categories of patentable subject matter. In other words, if the examiner reads the claim and sees that there is a process, a machine, manufacturer, or a composition matter being claimed, then that at least at first that claim is patentable. Now, the examiner must then go on to what they call Step 2A. Okay? Step 2A, or what they call Prong 1 of Step 2, the examiner has to read the claim and decide if the claim recites a judicial exception. If the claim recites an abstract idea or one of those judicial exceptions, then the examiner must decide if that abstract idea is one of several different kinds of abstract ideas that the PTO has identified. Examples of these abstract ideas include mathematical concepts such as formulas or mathematical calculations, or certain methods of organizing human activity, such as economic principles, for example, transactions between a buyer and a seller, or the transfer of financial data from one place to another, or managing personal behavior of people. Another kind of abstract idea are called mental processes. These are concepts or things that can be done in the human brain or that people just think about and can calculate in their own minds. If the claim has or says any one of these judicial exceptions or abstract ideas, then the examiner must do a further analysis. Of course, if the claim does not say any of these judicial exceptions or does not say an abstract idea, then this claim is eligible to be patentable, and the analysis stops here, and the examiner just goes on to normal examination of the claims. Now, the next part of step A, prong 2, if the examiner does find a judicial exception, then the examiner has to decide whether the claim as a whole integrates the recited judicial exception into a practical application of the exception. Now, this means that the claim that applies, relies on, or uses the judicial exception, such as an abstract idea, in a way that imposes a meaningful limit on that abstract idea or judicial exception. Okay. Now, we'll go through a couple examples in our discussion to give you a better idea as to what that means. Now, of course, if the examiner decides that the claim does have a practical application of an abstract idea, then that claim can be patentable. But if the examiner decides that there is no practical application, then he has to continue further analysis. Now, at this point, the examiner has to look at whether or not the claim has what is known as an inventive concept. The claim has to decide whether or not the claim recites something, what they call significantly more than the abstract or idea or judicial exception. This means that the examiner has to look at the claim to see whether or not the claim says anything else that might be inventive or different from the prior art, or that might be practical in terms of how inventive the claim uses that abstract idea. There are some recent cases at the Federal Circuit that are significant because of what the court was saying, even though many attorneys in the field have thought that the Federal Circuit still has not yet given a clear direction of how to apply the subject matter eligibility test. But it gives us some ideas as to what we can do and how we can protect our clients in drafting their applications and how to protect their inventions. One recent case, it was called Freestream Media Corporation versus Alfonso Incorporated. This was a case from the Federal Circuit in May of 2021. In this case, the patent was directed to a system for providing a mobile phone user with targeted information, such as advertisements, based on data gathered from a user's television. Okay. There were three main components in the claims: a network device, like a smart TV, a client device, like a mobile device or a mobile phone, and a relevancy matching server. Okay. Now, the claims also recited that the client device, or the mobile phone, for example, included a security sandbox that constrained or limited what each of the applications running on the device were permitted to do. In this case, the Federal Circuit said that the claims were invalid under Section 101 because they said they read the claims and interpreted the claims as being directed to an abstract idea. And the abstract idea was gathering information about television user viewing habits, matching information with other content, and sending that content to a second device. So basically, the Federal Circuit said that the steps of gathering information about television user viewer habits, matching information with other content, and the step of sending that content to a second device was abstract, or was just a general idea. Okay. The Federal Circuit also said that even though that the claims recited specific elements, namely a network device, a client device, and a relevancy matching server, they said that the claims simply recite the abstract idea will be implemented using conventional components and functions generic to the technology. So in this case, what the Federal Circuit was saying was that if your equipment or the elements in the claim, that is the hardware, are nothing but conventional elements, are elements known in the art, and all they're doing is implementing the steps or the functions that you think are the invention, then it is not patent eligible. Right? As I said earlier, oftentimes if you are just implementing a process or a function or a method on a conventional network or on a regular computer or a computer network, many times it is not considered patentable subject matter. Another recent case that is important is the case of You versus Apple. This case was decided in June of 2021. In this case, the claims recited an improved digital camera that had a first and second image sensor, lenses, first sensor, and you can read the rest. And in this case, the Federal Circuit said that the claims was directed to an abstract idea of taking two pictures and using one picture to enhance the other in some way. In this case, the court said that the claimed configuration does not add sufficient substance to the underlying abstract idea of enhancement. Okay. Namely, that the enhancing of one photo using data from another photo, and the generic hardware limitation of the claim merely serves as a conduit for the abstract idea. Here again, the Federal Circuit is saying, if all your hardware is just regular computers or prior art computers or prior art technology, and all you're doing is using that prior art technology to perform the functions or the methods or the process, then you are not necessarily patent eligible. Your claim is not patentable under Section 101. Another case is the case of Cosmo Key Solutions versus Duo Security. Okay. In this case, the patent was for a method for authenticating a user to a transaction by transmitting a user's identification via a first communication channel and activating a normally inactive authentication function through a second communication channel for a set period of time. Okay. Now, in this case, the Federal Circuit looked like as if they were changing their decisions, their point of view differently. In this case, the Federal Circuit said that the patent claims were eligible, that they were patentable, because the focus of the claims is the advance over or the improvement over prior art authentication systems, which constitutes the necessary inventive concept and under step 2 of the Mayo-Alice framework. They basically said that because the claims recited an improvement over the prior art, this was enough to be an inventive concept that made the claims patentable. Okay. In this case, the court did not focus on the claims reciting specific elements. Instead, they focused on the abstract idea being tied to an inventive concept. So we can skip the last case because. So let's talk a little bit about how do we cope with these kinds of decisions from the Federal Circuit that will be applied by the U.S. Patent Office when they prosecute a patent application. It is very important that you prepare your patent applications to thoroughly describe your invention. And you have to thoroughly analyze the invention that you are going to prepare a patent application for. If you have a patent application or an invention that relates to software or to a process or to a method that is going to be implemented on a computer or on a network of computers, it is very important to prepare the specification so that you describe what is the inventive concept, what is this process, this software, or this function, or this method doing that's truly different from what has been done before, so that you can hopefully incorporate that inventive concept into the claims itself. Also, it's very important that the application discuss in detail a practical application of the invention. How is this invention going to be used in the real world? Okay. Also, it is very, very important to disclose and describe what problems are being solved by the invention. You know, if it is just calculating a number, it is very important to say, what is this number or what is this calculation eventually going to be used for? How does it apply to the real world? It is very important to describe the structure and the operation of the invention. And when I say structure and operation, I mean what hardware components is it using? Does it need a new hardware component that's never been added before? Does it modify the hardware component in any way? Does it make the hardware component work or operate in any way different than what it normally would do? Also, it's important to describe the components and the structure and steps of the operation. Okay. Does the step require some very unique calculation? Does the step or the method require some very different operation of the hardware in order to work? It's also very important to describe the interaction between different components and also different processes that are both internal and external to the invention. Okay. When I say interaction, how does each part or each step of your invention work together and so that they perform their necessary functions? And also, how do they interact with the real world? Is it all internal to the computer, or does it generate or perform something outside of the computer or network itself? So, for inventions such as for software or computer implemented inventions, it is very important to really differentiate your invention from regular economic practices, regular methods of organizing human ideas, and doing more than just mathematical formulas or relationships. So examples of how we should detail our invention in the specification is, for example, what types of communication or transfers of data are being done between physical components? How is data being manipulated, changed, or restructured? How are we improving the functioning of the computer? How are we solving problems or deficiencies that are unique to computer technology or to computer networks? How is our invention communicating or transferring data between physical components and not just internal to the computer? And very important, how is the final resulting data externally outputted or displayed or applied that is different than just generating numbers? In the same way, we have to incorporate this type of thinking when we're drafting the claims. Similar to what we do in the specification, the claims should really recite the interaction between the components or steps that are within the invention itself, such as within the computer, but also the interaction between components or processes that are external to the invention. What kind of output do you have? How does it affect other machines? How is the real world interacting with your invention? Okay? And this is also very important to differentiate from the prior art. Very often, there is one part in your invention that is different from what is being done before, and that element is very important to put into the claims. Okay. And so you also need to describe components and steps that add significantly more than just those abstract ideas. And very importantly, you have to describe in the claims some technological effect or some kind of technological result that the claims, that the invention recited in the claims accomplishes. During prosecution, you should, if your claims are not sufficient to overcome a 101 rejection, then you need to be prepared to amend the claims to incorporate those features that we just discussed, such as the components that differentiate from the prior art, and you need to describe those components to add significantly more than just the abstract idea, and to add some technological effect or result based on the inventive concept or practical application. Very important also to you to speak with the examiner during interviews. Very often the examiners are encouraged to help understand what the inventive concept is, and it's very important to talk to them so that you can explain to them what is the inventive concept or what is the practical application. So, some conclusions. Again, there is still uncertainty with how subject matter eligibility is applied. Okay. But it is best to try to prepare for those issues during the preparation of the application. And we should use the disclosure, the specification, and the claims to fully describe in detail what your invention is in case of a 101 rejection. think my time is up for this presentation. Thank you very much.
接下来呢，是第二个 topic。那在这个段落，我是要介绍 Carnegie 这个案件里面针对请求项解释原则里面提到的最宽广合理请求项解释原则。在这一次的这个介绍当中呢，我是希望呢，透过本案件的一些技术的背景，来协助各位听众去了解整个请求项解释的原则，不单单只是针对法律的部分去做分析。那这边首先我先针对这个案件的事实跟背景呢，来做一个简介。有类似于这个台湾的这个举发程序哈，在这个案件当中呢 ，Carnegie 它是针对这个 Velodyne 它美国专利号7969558。向美国的 USPTO 提起两件的那个多方复程程序请求，也就是 Interpreted Review。它针对两组请求项主张显而易知的无效。那 USPTO 在那个 PTAB 的审理以后呢，它做出了558专利的两组请求项，相对于主要的这个证据 Mizuno 呢，都是非显而易知，而且是有效的。那我这边稍微讲一下，就是这个案件在 PTAB 阶段呢 ，Carnegie 它除了用 Mizuno 这个案件作为前案之外呢，它也有用其他的一些次要的这个前案去作为辅助。但是到上诉到 CF7 的时候呢，它主要就是针对 Mizuno 这个部分来主张说 PTAB 的做出的决定是错误的。所以这大概是这个案件的背景。那这个案件其实就是说，它并没有相对应的这个诉讼在进行当中，所以呢，就是单纯的去针对这个两个竞争者去提对方的这个专利去提无效。那这两家公司呢，就 Q 公司跟 B 公司呢，他们都是在制作这个类似这个无人车再去侦测四周环境的这个装置的竞争者市场上面，所以呢。Q 公司就向 B 公司的专利，Q 公司就针对B 公司的专利去提起这个 IPR 程序。那在接下来我们看看，当然要去讲说整个请求项它的无效的部分呢，我们要首先看看请求项的这个内容是什么。那本案的请求项呢，可以看到在这个我们这个 PowerPoint slide 上面有把它列出来。那我先讲一下，就是说很有趣，就是说不管是在判断专利侵权不侵权或者是有效性呢，第一个步骤都是要把请求项的这个去做一个解释，才能够接续下来的工作。那在这个专利侵权的案件当中呢，当然就是专利权人会希望他的权利是解释的比较广，也涵盖到这个被侵权的这个对象。但是在这个当他的专利被无效的时候呢，他又希望说可以解释稍微窄一点，去跟这个前案去做一些区隔，这是蛮有趣的一些现象。但是就这个请求项解释，它还是有一定的标准，特别就是说，在美国这个实务上面呢，他会去把在有专利侵权诉讼的这一部分的案件的请求项解释跟没有，就是一般在申请过程当中的请求项解释呢，会有两种不同的原则。那这背后其实是有一些原因的哈。那我稍后如果有机会的话，再跟大家去分享我的看法。那我们可以看一下，就是投影片里面这边的这个右边的图示哈。那我搭配左边的这个文字来向各位稍微解释一下。你可以看到，就是说我特别把这个红色的 Lidar 标出来，因为这整个案件的争点就是在于 Lidar 在这个 claim 里面要怎么去解释，特别是在这个最宽广合理范围解释的这个 principle 之下是怎么解释的。我们来看一下，它这边有提到里面有 Lidar-based 3 key point class system。第一个就是 support structure。那你可以看到在右手边那个标号大概是就是100那个地方，150的地方，它是整个外壳。所以它整个外壳就是一个 support structure。 那再接下来，它这边是 a party of laser emitter supported by the support structures， 就是在上半部里面，我们看左边它这边就是上半部标号大概14的地方，它那边是一整组的这个雷射光发射器。那在接下来我们可以看到，就是下一个元件是说是关于感测器的部分。那感测器的部分呢，我们看到右边这个图是中间的部分它就是左右上下这4个其实是发射器，然后它的这个就是接收这个反射的光的部分呢，是在后面那个柱状的元件里面，位于在那里面那个就是接收的地方，也就是经过光的发射跟接收呢，来去量测它侦测物到这个发射器之间的一个距离。那第3个元件，它是说是一个 rotary component configured to rotate， 后面有一些特征，它基本上就是它转速非常快，可以达到每分钟200 RPM 的这个转速。那可以知道，如果说像右边这个它装在车上用快速的旋转，然后经由光的发射，然后接收去量测这个它周遭的物体跟这个发射器的距离呢，就可以去侦测到这个车辆四周障碍物的它具体的距离跟形状。那现在的问题就是说，这个 Lidar 要怎么解释？那跟这个提供的 Mizuno 这个前案的这个技术所揭露的这个技术内容又有差异。那先讲一下为什么就是说这个案件要采这个最宽广合理解释那这个案件是这样子，就是在PTAB 针对在2018年11月13号提出的这个领证后的3个程序包含了这个领证后复审程序、多方复审程序，也就是本案的多方复审程序，还有领证后商业方法有效性复审程序请求项的解释原则，是从原来的这个最宽广合理解释原则改为跟专利侵权部分的 Phillips 原则是改成这种后面这种相对来讲比较严格的原则，但是它的时间点必须要考虑，我这边也标示出来是2018年11月13号。那在本案呢，宽乐举他对558专利提起的这个interpretive review是在2017年11月29号，所以 CAFC 在审理本案的时候还是采取了这个旧的准则，所谓的最宽广合理解释的原则。那至于为什么在2018年11月13号 PTAB 要把这个解释的原则改成 Phillips 原则，因为这几个程序后面通常会牵涉到对应的这个专利侵权诉讼。那你如果说在专利侵权诉讼的解释原则跟你在另外一边在 USPTO PTAB 这个程序里面解释的原则不同的话呢，可能会产生一些问题。那也就是说，因为可能在 PTAB 这边的这个解释范围比较广，相对来讲是比较容易去把它无效掉的。那其实这样子对整个制度来讲并不是这么公平，所以后来就针对后面针对这3项的这个领证后的程序呢，他把他的这个最宽广合理的解释原则改为 Phillips 原则。那其实事实上来讲的话，针对很多的案件来讲的话，其实不管是采用这个最宽广合理解释或采 Phillips 解释原则，结果会一样。对啊，那就主要就是看在整个这个个案的事实上面的差异那有一些其实会一样，那有一些又会不同，我们后面再稍微解释一下。我们来稍微解释一下最宽广合理解释原则跟这个 Phillips 原则的之间的关系那我们刚刚提到就是说，其实美国的这个领证后的审查这个claim mention 或者是我们叫做这个请求项所载的发明的程序呢，有很多种，它包含了这个 reissue， 然后这个 expletive examination、interpretive examination、post-grant review 等等interpretive review、IPR， 也就是本案的这个所采的这个程序，然后还有这个 supplemental examination 等等。 那就可以知道，就是说这其中有3个后来是他在请求项解释原则已经改成从这个最宽广合理解释原则改为那个 Phillips 原则。那长久以来呢，在专利侵权的这个案件都是美国联邦法院审理，那他们针对专利侵权案件呢，都是采是 Phillips 原则。这边可以大概给各位就是有一点点大概的这个概念的介绍。那 NPEP 呢，针对什么叫最宽广合理解释原则里面，它有稍微做出一些解释。它里有提到说 ，USPTO 在解释请求项时，应给予最宽广、合理而且与说明书一致的解释。那就是在这个解释的时候呢，最常被容易忽略到一部分就是第2项合理的部分。那什么叫合理？通常也会跟第3项与说明书一致有关系啊，因为当从字面上解释的时候，会产生一些不合理的情况。那也就是本案的这个争点的重点所在。简而言之，就是说，在 USPTO 在解释请求项的时候呢，并不是仅仅仰赖请求项中的文字用语而已，而且必须是所属技术领域具有通常的知识者，在审阅过专利说明书后，会给予请求项的最宽广合理的解释。也就是说，必须是审阅过专利说明书以后，再针对这个请求项里面的特征去做解释。而且它除了这个就是尽量宽广以外，就是照它字面意思尽量的宽广去解释以外，后面有一项很重要的这个要求就是合理，必须合理的解释。那至于 Phillips 原则呢，我这边也稍微跟大家介绍一下，它这边有几个准则，就是说它也是必须是一个 ordinary meaning， 就是根据这个patent documents 来去做解释。然后这边的 patent documents 就除了说明书以外呢，还包含了申请历史档案的部分。然后再来就是说，法院也认可，就是说，当申请人或者是 patentee， 就是专利权人，他对他自己的一个某一项的技术特征有他自己特殊的解释的时候，那必须尊重这个申请人对他这个文字特别的解释那就特别是在文字的部分，我们也可以看到现在的这个专利说明书，特别美国的专利说明书呢，有很多呢，它都是会去自己做一些定义，比如说在这个本文当中呢，我们提到的某一个特征它是什么意思？那提到了某一个特征，就是技术特征，它代表是什么意思？那其实这种方法呢，有助于以后如果诉讼的时候，或者是专利的这个有效性有争议的时候呢，可以去做一些比较清楚的厘清。那如刚刚所说的，就是说 Phillips 原则，也就是在侵权的这个案件中，它很重要的一部分是在这个申请历史档案，也就是这个 prosecution history， 还有在这个历史档案中其他的一些证据。那原因就是说，在这个申请的过程当中呢，你会去针对你的特征去做一些描述呢，应该通常是会有一些原因的，所以这个审查人他会，或者是法院这边呢，他必须抱持一个比较怀疑的态度去看待你为什么会去针对这个特征去做一些描述，甚至后去跟这个前案去做一些区隔。那在这个解释的时候呢，基本上大概有区分为2种证据啦。那请求项解释它其实基本上就是一个综合各种证据以后做出的一个决定，决定说某一个这个特征在这个请求项里面它应该怎么解释。那解释的证据来源包含了所谓的 intrinsic sources 还有这个 extrinsic sources。那就是也中文我们就内部证据或者叫做外部证据在那个专利侵权判断要点里面的文字是这样子。那这些内部证据呢，基本上包含了就是请求项文字本身，然后专利说明书图示，还有申请历史档案，包含了这个之后如果有一些无效程序里面的一些文件等等，所以它的范围就是必须跟专利说明书的案件本身有直接的相关。 那所谓的一些外部证据呢，就是它是独立于这个专利说明书的证据，譬如说是一些学者的这个文章啊，一家专家的证言啊，还有这个字典等等，还百科全书等等，这是属于外部证据。那在这个就是判断原则里面呢，内部证据是优先于外部证据。如果这两者解释有一些冲突的话，那我这边特别提到说，在本案里面的 expert testimony 就是专家证词占一个蛮重要的角色啊，这或许是跟就是我国这边的这个实务上有所区别的地方。那我国的专利侵权判断流程这边应该大家很熟悉哈，就是在我们的专利侵权判断要点，也就是智慧局出版的这个文件里面，它所做的流程。据了解，好像这个流程的部分呢，像是日本那边的某位学者他这边所发展出来的哈。那对就是判断者来讲的话，这个流程图其实是蛮有效的，蛮容易懂的。但是在美国上面，他们的实务上是没有这样的一个流程图，但是基本上是蛮符合美国它判断流程的这个流程。那我可以说，就是我们的了解，就是我国的专利侵权判断流程图，还有它一些包含解释侵权的这个部分呢，跟美国 Phillips 的这个解释原则是类似的，那这边我们来看一下那个专利侵权判断要点，在我国这边呢，它有提到就是说，必须是以最合理的方式解释。它这边也提到说，就是说，如果说明书中另有定义的时候，应该是以该定义来去做解释哈，也就是美国这边实务上的就是那个 patentee can be his or her lexicographer， 怎么去解释这个请求项，它可以有自己的解释，而且必须给予适当的尊重。当这个这边有提到说有异议必须厘清的时候，可以参考说明书申请专利范围的内部证据；人有异议的时候，可以去参考这个外部证据等等。好，那我们这边后面会有提到这个有异议的部分的文字是不是很合适？那这个在我国这个专利侵权判断要里面有一个原则也是一个衡平原则，就是我们看到就是在红字部分，我特别把它强调，就是不应该把非属专利权的范围内容解释至请求项中。就是说，如果它并不是发明人本身的贡献的话，不应该把它去列入到权利范围当中，请求项的权利范围，避免不当的扩大它的权利范围。那我们再看到，就是在我这部分里面也提到，就是说，在专利侵权的时候呢，在解释请求项，它并不是以最宽广合理的范围去解释，这也就是在这部分呢，去针对在我们的这个申请过程当中的解释呢，去做了一些区隔。它必须是以完整的申请历史档案朝专利权有效的方向予以解释。所以我这边来讲，个人的观察就是说，我们可以这样说，最宽广合理的解释跟菲利普解释，其中有一个蛮重要的差异点，就是在历史档案部分。那在最宽广合理解释的部分呢，它原则上是依照请求项的文字，然后参酌说明书。那这个历史档案部分呢，就不会去过度的重视它，但相对的，在你但有专利侵权诉讼的时候，这个历史档案角色会变得非常的重要，因为就是这个历史档案当中包含了你可能在针对审查委员发出的审查意见提出修正答辩等等这些文字或者是修改的方式呢，会给予很放大的方式去把它解释。比如说我们刚刚提到，在美国的实务中，他用一个 skepticism， 就是说他会怀疑，就是说你为什么会这样讲，应该是一定有一些某种原因才会去做这样的去做申复或是做修正。那但是仍然是要朝专利权有效方向予以解释了那是就是如果说怎么解释都是不明确的话，那这个 案件就必须朝专利有效性中的不明确的部分去进行，那只能这样去做，但不能够去为了要让它解释成有效而去改写那个请求项里面的特征，这是不允许的。那我们再回到本案，那本案的这个 Lidar 里面的案件里面都有提到，就是说 Lidar 它其实是一个 Laser Imaging Detection and Ranging 的缩写。那我们可以看到，是从文字当中，如果其实大家这个4个文字也不难理解哈，它基本上就是用雷射光去做这个量测的这个方法。那在这个本案的558专利里面呢，它是透过光脉冲发出以后，再回到发射器附近的侦测器，它就可以量到一个距离。它在这个业界有一个名词叫做那个 Positive of Flight Lidar， 就是 PLLC。它的原理其实蛮简单的，有点就是我们在高中或国中物理里面提到的，就是速度等于距离除以时间啊。那只要把这个速度呢，因为光的速度是一定，然后时间上量测到出来，距离就出来了啊。那它针对，因为它扫描的这个对象呢是范围很广，所以每一个光达距离它量出来的一个单位叫做 pixel， 是一个像素单位，一个影像单位。那我从右边可以看得出来，就是在利用这个这种技术，就是 DOF 这种技术，脉冲飞时测光距离光达测出来，它呈现右边就可能很多是这种光点，这种在经过运算出来它显示的影像，它就可以经由这样子光发射，然后再接收的方式，分测出它四周这个障碍物或者是环境物质它距离的位置跟它的形状是怎么样。这也就是本技术的本案558专利它的技术的一个重点。好，那再接下来就是说，Lidar 这个字要怎么解释呢？传来举他主张就是说，因为根据字面解释，那我们看到，其实在本案我国这边很多案件就是会主张说，一开始确实是要从字面去解释了哈，就是说，因为 light detection and ranging 它应该就是用光来测量距离的一个系统，所以我们就可以知道，就是说，就挑战这个专利有效性的一方而言，他当然会希望说，就是说你的这个 Lidar 解释的比较广，它比较容易无效掉。但是呢，这个PTAB 跟 Velodyne 或者 V 公司这边呢，他们就是说，根据专利说明书呢，应该要解释成脉冲飞时测距光达，也就是单单是这种用光测量距离的方式，还是这个 Lidar 应该被赋予的解释，而不是所有用光来测量距离的系统都是可以解释涵盖为 Lidar 的 system。这就是这个案件里面最争议的部分，所以其实也不是那么难懂啊。接下来我们来看一下这个前案 Mizuno 主要的这个 primary 这个 prior art， 那后来也是在这个 CF 阶段的时候，真正有主张的单一的一个这个 prior art。它这个装置呢，是一个来量测这个圆柱形铜棒它的外周圆是不是有缺陷的一个装置。那我们可以看到，就是说右边这个元件10号，就是它的这个圆柱形长条形的这个铜棒，上面跟下面那个都是一个是正面，一个从侧面。那四周呢有一个环形状的这个结构，旋转盘30，可以看到它会快速的旋转。然后呢，这个标示40的是一个感测器，它会面向这个中心的这个铜棒去发射雷射光，然后又快速的旋转。那这边的差异就是说，它经由同条表面反射器到该雷射至位置感测器距离感测的位置来判断，就是这个铜棒的这个表面上呢是不是有缺陷，所以它是依据光反射回来接收到的位置来去判断是不是有缺陷。我们刚刚提到那个558，就是刚刚提到本案的这个专利呢，它是用时间去做这个判断的这个，所以这个是2个最大的缺点。我们再看到这个部分， 来协助各位了解因为我想这个可能跟大概高中的时候的这个物理就应该会有，就可以大致上的了解所以应该即使是不同技术背景的同事，应该的听众应该也不会太难了解。我们看到就是说右边这个部分它这个光线一旦发射出去了以后呢，如果是它这个像右边这个我们看到这圆柱形的这个断面，它如果是有一个上面有凹下来缺陷的时候，发射出来的光线，因为那个表面不平整，它弹回去的位置呢，就会跟它进来的时候也是有一个角度，所以在接受的位置呢，就不会是它当初发射出来那个位置。那它计算的方式就是说，原来这个圆柱棒呢到这个发射点的距离是一个大 R 的距离，然后呢扣掉这个，如果它说是表面没有缺陷的话，它固定的距离会是 D， 所以这个量出来距离的那个圆柱的在那个位置的半径为是 R 减 D。那相对的，如果说这个圆柱棒表面有一些缺陷的话呢，它反射的位置会不一样，那出现呢就会有一个距离差，就 delta D。这时候半径的位置，从这个圆心到那个缺陷位置的半径的位置就会是大 R 减掉小 d 加上 delta D， 就是用这种方式来去量测整个铜棒是不是表面上是不是存在缺陷也就是它检测这个产品品质的这个好坏的部分的方式。那最下面这图就是它把图表化它可以发现的，如果在这个圆周到拍的部分，就是可能在接近中间的部分呢，它也发现了一个它的形状是一个凹下来的那这样子来讲的话就是说这两个其实就是都是用光去量测距离，但是它的这个量测的方式其实不同。那就这个Velodyne V 公司它的角度而言，这两个都是用光去量测距离，所以这个米珠这个前案的它的内容其实应该涵盖到这个558专利独立请求项里的内容，也就是他认为就是558专利请求项写的太广，他并没有去做进一步的限缩了。但是在 CAFC 这边，他是同意 PDAB 根据专利说明书把那个 Lidar 这个字限缩为脉冲非时测距光达。它原因就是说，因为整个558专利说明书的全文呢，相当的暗示558请求项所记载的 Lidar 就是脉冲非时测光距离。脉冲非测光距离跟这个Mizuno它这个三角测量这边有提到，就是说，在这个案件当中，他们俩那个就是把这个就是 Mizuno 的它的这个技术叫三角测量。那我们可以回到前面一个这个图片可以看到，右边这边它确实有点类似，因为它反射的位置跟它原来的这个角度不一样，会呈现一个角度，然后这个距离。通常像这种情况之下呢，就会有一个类似可以用三角函数的方式去做一些计算。那我们再稍微快的继续进行下去就是很简单，就是说在说明书来讲，只要是这个领域的人都知道，里面的 Lidar 你要写的就是所谓的脉冲非时测距光达，而不是其他任何的这个光测量方式。那专家证人的部分呢，就是 Velodyne 他的证人呢，他的引用的文章其实也是把这个脉冲非时感测距离跟三角测量是做区隔的。然后虽然说就是Velodyne他这个专家证人，他把这个 Mizuno 的技术呢描写为镜面反射系统，但是他也承认这个 Mizuno 并不是脉冲非时测光距离。那所以这两者差异其实就是Mizuno 是从何处接受光反射来量测，那本案的这个558专利是用什么时候接受到反射光，这两个的技术方案其实是不太一样。那就是因为在这个美国的案件当中，他们通常会引用前案来作为比拟。那Velodyne它是用了另外一个案件，那个案件当中呢，就是有提到，就是说它 并没有去特别的局限，然后就是在那个说明书当中也并没有把这个两个特征，就是 file label restoration 或是 block label restoration 做一些两者有什么本质上的差异，并没有去做一些区隔，所以在那个案件当中，它会把那个特征同时的涵盖到两种情况。在本案的情况就是这样子。那我们再看一下我国的这部分呢，有些案件有提到，就是说，在我国的专利法里面的这个是说得审酌，这边常有一些争议，就是说是应该审酌，还是说必须某些情况下才去做一些去参酌专利说明书。那有一些人认为说，应该只有不明确的时候才需要去看。那在我国也有一些案例，各位这边可以看到，就是说他认为说，只有在不明确的时候，才需要去参酌说明书。但是也有一些判例是认为说，应该不管怎么样都应该要参酌说明书啦。那就是但是在我国的这个审查基准里面呢，它的里面提到就是说，还是应该在参考说明书。而且它里面用的文字跟美国的这个最宽广合理解释原则是一致的。那我国的专利侵权诉讼中所参考的这个智慧局所出的专利侵权判断要点的内容，跟美国实务的菲律宾原则其实大致上是一致的部分。那我个人的建议就是说，当然我们后面其实我这边在举发这部分也做了一些蛮大的修改，未来的可能专利举发案件部分后续的程序会采民事的程序等等。但是就原则上来讲的话，就争议性比较大的部分的话，我们是不是可以做一些区隔？也就是针对专利审查阶段后续的行政救济，还有没有涉诉的这个专利举发案才最宽广合理解释原则，因为这样的审理其实在效率上是比较好的。那涉讼的部分的举发程序还有专利侵权案件，因为它其实比较严重，就案情来讲的严重，必须要比较严格的去检视所有的证据那来去做采这个规定的原则。那其实请求项解释原则是蛮复杂的部分，有机会我们以后再做一些进一步的讨论。那因为时间的关系，我想把这个时间要交回给Juan。Juan, so you need to start your second section. I will switch the control to you. Okay?
Okay. Hello, everyone. Now we'll go to our second topic, is design patents under U.S. law. If you cannot see my screen, please let me know so I can double check, but I think it should be showing right now. Anyway, so in this topic area, we will discuss some of the updates, the strategies, and practice tips in terms of
Sorry, you need to open your PowerPoint slide.
Okay.
Your PowerPoint slide.
Is that better now? Okay. No. I'm assuming it's up now. So let's get into the topic. Okay. In this discussion, we will start off with some comments about the current trends in the law, namely the current state of design patent law in the United States. And we will discuss some of the more recent and important design patent cases that you need to consider. Then second, we will discuss some practice tips and some strategies, as well as some fundamentals about design practice. And finally, we will come to some conclusions. In the practice tips and strategies section, we will discuss some issues about application and preparation, and then we will discuss some prosecution strategies and examples. Now, what is the current state of design patent law in the United States? Actually, in recent years, design patents have actually become more prominent in U.S. practice. In May of 2015, the U.S. government finally adopted the terms of the Hague Agreement concerning the international registration of international designs. And so at that time, U.S. design statutes had to be made more consistent with the industrial design registrations in other countries. For example, whereas our original design patent term was 14 years, it is now 15 years to be consistent with the rest of the world. And also for those of you who are probably very familiar with the litigation between Apple Computers and Samsung Electronics that went as far back as 2011, where it was basically known as the cell phone or mobile phone wars between them. It was not only involved Apple and Samsung, but many other companies that were in the business of manufacturing and selling mobile phones around the world. Now, those lawsuits between Apple and Samsung were not only in the United States, but also in other countries in Europe and in Asia. And many of the patents that they asserted against each other were not just utility patents, but many of them were design patents. And so because of that litigation, it's clear that the appearance, the design, and the outer appearance of various consumer products is very important to technology and to the sales of those products around the world. In terms of how viable design patents are, to get them in the United States, there have been many false information about how difficult design patents are obtainable in the United States. Actually, while the number of design patent applications continues to grow, the number of applications being filed at the USPTO continues to grow, the allowance rate of design applications is currently up to 85%. Many years ago, that number was only as low as 50%, but it has grown considerably as the case law and the practice has developed. In litigation, between the years of 2008 and 2020, in district court litigation that had to perform validity determinations, design patents were actually upheld as being valid 88% of the time. And in post-grant proceedings at the U.S. Patent and Trademark Office, design patents have actually survived 78% of the time during inter-party reviews and 81% of the time in post-grant review proceedings. So it appears that design patents are actually quite obtainable and quite enforceable in the United States. One recent case that kind of highlights the importance of preparing a design application very carefully is the case of In re Surgisil. This was a case that was decided in October of 2021 at the Federal Circuit. Now, this was actually an appeal from the U.S. Patent and Trademark Office, specifically the Patent Trial and Appeal Board, to the CAFC. The Federal Circuit had actually reversed the decision of the PTAB, and they held that they affirmed they had reversed the decision that the design claim is limited to an article of manufacture identified in the claim. Okay. What had happened was the Patent Trial and Appeal Board had rejected the design on the grounds that even though the design was directed to one particular type of article, they had applied the prior art of another article against it. Okay, the design in question was actually a tubular device that was used for medical purposes, and they had cited as the prior art an art tool, and the design patent owner had brought it up to the Federal Circuit, and in the Federal Circuit had said that you cannot make that kind of rejection. Basically, you have to reject a design based on a similar article and not something completely different. Okay, and in the words of the Federal Circuit, a claim, the rejection does not broadly cover a design in the abstract. Okay, so in effect, what the Federal Circuit was saying, it is the title of the invention in a design application that is very important, because how you write the title of the invention can avoid and distinguish the claimed design of one type of article from the prior art design of a different type of article. And we will discuss this in further examples a little later. Another recent case that had a lot of opinion from the Federal Circuit was the case of Campbell's Soup Company versus Game & Plus. This case was decided in August of 2021. Here, this is also a case from the Patent and Trademark and Appeal Board in two separate inter-party reviews. At the Patent Office, the PTAB, or the Patent Trial and Appeal Board, had said that had applied the idea of nexus in determining the obviousness of the design. The Federal Circuit reversed the Patent Trial and Appeal Board's decision because they said that the Patent Trial and Appeal Board did not properly apply the law. The Federal Circuit said that when you are determining obviousness in a design patent, you must consider evidence of objective indicia having a nexus to the claims. Evidence of objective indicia is another way of saying secondary consideration. Okay? It is evidence of things such as commercial success and long-felt need. And under design patent law, when you are determining obviousness, okay, there has to be a nexus, or another word, it has to be a connection between the evidence of things like commercial success to the design that is actually being claimed. And in the words of the Federal Circuit, they said there must be a legally and factually sufficient connection between the evidence and the patented invention. The Federal Circuit also said that a nexus or a connection may be presumed, you can assume it, if the evidence is tied to a specific product that is coextensive with the claimed invention, meaning that the product is the invention disclosed and claimed. What this means that if you are going to try to fight against an obviousness rejection or a claim of non-obviousness against your design patent, you have to present evidence that the design that you claimed was the one that was commercially successful or that fulfilled a long-felt need. Okay, so if your design patent is exactly the same as what you are actually selling as a product, then that is a nexus, or that means that they are connected and that there is a coextensive relationship between the design and the product. Okay. The Federal Circuit said, in determining coextensiveness, the question is not whether unclaimed features are insignificant to a product's ornamental design, The question is instead whether unclaimed features are insignificant, period. What this means is that very often when you have a design patent, there are features in the patent itself that are not claimed or not significant. Okay? If those unclaimed or insignificant parts end up being important to what made the product commercially successful, then you have a problem. You may have a problem of the product and the design not being coextensive. Okay? If your product that you're selling that shows that your design was commercially successful is different or is successful only because of the little features that you did not claim in your design patent, then you do not have coextensiveness between the two, and that can become a problem. Two older cases that are very important under design patent law are Sport Dimension versus Coleman. This was a case from the Federal Circuit back in 2016. The Federal Circuit, in that case, affirmed its prior holding that functional elements in a design need not be factored out when analyzing design patent claims. Now, what does this mean? A design patent is supposed to be the appearance or the ornamentation of an object. Okay? It can be a functional object, such as a tool, but it is the appearance of that object that has to be what is claimed in the design patent. Okay? The functional features of that object are not important. Okay? And if the features of the object are if its functional parts are what's important to the design, then in many ways, under U.S. law, those parts cannot be protected under the design patent laws. They have to be factored out, and only the parts of the design that are just there for appearance or for ornamentation are what can be protected. Okay. So, for example, if you have a design patent of a screw, the parts of the screw that are used for function, namely the screw part, cannot be protected under the design patent unless there is some feature in the screw part that is not functional. It's not there because it allows the object to be screwed into a wall, but it's only there for decoration. Okay? Only the decorating parts are what can be protected under the design patent. Another case, even earlier from 2008, is the case of Egyptian Goddess versus Swissa. This is an unusual case because this is a case where the Federal Circuit made its decision en banc, namely all the judges on the Federal Circuit came to this decision. Usually, the Federal Circuit that makes decisions based on 3 or even 5 judges hearing a case and making a decision. In this particular case, all 15 judges of the Federal Circuit came together, heard the case, and made the decision. And in this case, the Federal Circuit said that the infringement of a design patent would be determined based on the ordinary observer test and not the point of novelty test. Okay? This simply means that in a case where you are determining if the design patent is being infringed, you have to look at it. It has to be determined from the point of view of some ordinary person looking at the design and comparing it to the object that is accused of infringing the design patent. Right? So, how does this translate into preparing a better design patent application? You have to understand that in the specification of a design application, the function or the purpose of the claim design is not described. You do not describe what an object does or what it's used for. Okay? Very often I've come across applications where an applicant tries to describe what the object actually does. For example, they will try to describe that the object performs a medical function, or that the object is used to is a tool used to fix certain things, or that the design performs a series of very important computer functions. This type of language is not allowed to be in the specification of a design application. Any technical description of the function or purpose of an article that's in a design application has to be removed, and an examiner will actually require that removal from the specification. Okay. The only part of a design application that describes the object is the title of the invention. Okay. So that's why the case that I said of In Re Surgitso is very important, because it is in that case that the Federal Circuit said, basically taught us that we have to write the title of the invention very carefully, because it is what can distinguish the article of our design application from the prior art. Okay? The title of the invention, if our title of the invention, okay, says it's a medical device, it effectively the Federal Circuit effectively says the patent office or anyone else trying to invalidate our design patent cannot use a design of, let's say, a tool, of an art tool. Okay, it has to be something related. They can only cite prior art that is related to the article in our design application. And the only way we can describe our article is through the title of the invention. Okay. So, in the title of the invention of a design application, it is very important that we choose the words to balance it so that we can both distinguish the design in our application from prior art designs or non-related articles having similar appearances, at the same time wording it so that we do encompass any potential infringing articles that are important to the design patent, to the designer applicant. One very important concept that we always have to keep in mind when we are preparing a design patent application: the drawings are the most important part of a design application. And it is important to remember, engineering drawings are not design patent drawings. When I say engineering drawings, these are drawings that we use when we are actually designing technology. You know, the ones that show the dimensions of an object, the parts of an object, and so on. Right? In the past, from experience, I've seen many design applications where it is an engineering drawing that's being provided. And there are many changes that have to be made, because in an engineering drawing, there are many symbols that do not mean the same thing when it comes to a design patent drawing. I would even say that the drawings for a utility patent application are not the same as the drawings for a design patent application. The drawings in a design patent application are very much like a utility patent claim. All the drawings in an application must be directed to one claim design. So if you have drawings in a design patent application that are directed to different versions of the same article, it is not unusual for the U.S. Patent Office to have a restriction requirement, and you have to cancel drawings from a design patent application. This is very different from what is usually done in a utility application, where your patent attorney will often tell you it is not a good idea to cancel drawings. In design patent prosecution, it is typical to delete drawings that are directed to unrelated designs, that are not directed to the design that you intend to claim in the application. Another very important point is that all the lines and features in the drawings must be consistent. Okay? All the lines and features must be consistent across all the drawings. So if you have one feature in one drawing, that same feature should be represented in all the other drawings consistently. It is not unusual for certain lines to be missing from one drawing to another, and it is in those cases that the examiner will reject those drawings and require that they be corrected. It is very important to note that it is the solid lines in a design application that represent the elements that are being claimed. Hidden lines or dashed lines are used to show elements that are not claimed as part of the drawings. Okay? Compare this to engineering drawings where hidden lines are used to show parts that are hidden from view. Okay? It is in design patent drawings only that we use the dashed lines or the hidden lines to show parts that we do not consider part of the claimed design. They may be visible if you were actually to look at a physical example of the design, but for purposes of claiming in a design patent application, they are used to represent what we are not interested in. Okay. Now, examples of things that we would not claim in the design are industry standard components such as electric connectors, screws, handles, and so on. And also, we use hidden lines to represent internal components of machines or devices that may be visible in a design. Okay. Shading is a very important part of the design patent application. Shading is used to represent contours, elevations, depressions, and angled surfaces of the design. In engineering drawings, in contrast, or even in utility patent applications, shading is often discouraged because they are not intended to represent any contour lines. Actually, any kind of shading, especially in utility application drawings, are used to show the type of material. And that is very similar to what is being done in engineering drawings. In design patent applications, you need to use contour shading in order to show differences in contours, in angles, and elevations. And we will look at some examples in just a minute. Drawings should be enlarged enough to distinguish all solid lines from one another. Okay? This often becomes a problem in drawings in designs that have a lot of parallel lines. Okay. Now, prosecution strategies and examples. Okay. Typical formality rejections are elements in the drawings that the examiner will say that there are elements in the drawings that are unclear, such as screws, buttons, and locks, because they're often drawn very small. The examiner may also reject shapes and contours of elements are unclear. They're angled surfaces, and the examiner cannot tell from the drawings that does not have any shading the direction or the shape of angled surfaces or contoured surfaces or any parts that are upraised or recessed. Another typical rejection is there are details in one drawing that are missing or different in other drawings. And as I mentioned earlier, the examiner will often reject a drawing because their adjacent solid lines are too close and cannot be distinguished from one another. So, what kind of strategy should we be using? Okay. Now, as far as amending the drawings, if there are details that are not critical to a claim design, you should change those solid lines to hidden lines. If adjacent solid lines are too close, it is better to enlarge the drawings enough to distinguish the solid lines from one another, rather than trying to change the lines completely. And of course, we use shading to represent contours, elevations, depressions, and angled surfaces. Also in design practice, it is a good idea to have examiner interviews to clarify and explain the claim design and to differentiate the invention from any prior art. Examiners are also often available to make suggestions on how to amend the drawings to overcome their rejections. Here are just a few examples of designs that I've seen that represent what we should be doing. Okay? If you notice in figure 1 of this design, there are a lot of lines that are parallel to one another. Okay? In this particular design patent, these pictures were enlarged enough so that it was much easier to see the parallel lines. And if you notice, there are many surfaces that are at different elevations and different angles. Okay? And the shading is used to be able to distinguish those surfaces from one another. And if you look on, for example, on figure 4, you notice there are parts like the handle, which are all in hidden lines because those parts are not important to the claimed design. Here's an example of a remote control. As you can see from figures 3, 4, and 5, there are many different contoured surfaces. And in this kind of situation, you need to use the shading in order to distinguish the direction of their contours. In figure 1, you notice the shading is used to show parts that are at different elevations. And if you look at figure 7, you will see that there's actually a recess or a hole. Okay? But that part of the object is not important to design, and that's why it is only drawn in hidden lines. In this example, we see a combination of both solid lines, contour lines, and there are very distinct elements that are not being claimed, namely the joysticks as well as the buttons. And also if you look on figure 3, holes such as for screws, as well as the screws themselves, are drawn as hidden lines, even though they are probably actually visible in the physical object. They are drawn in this design as hidden lines because they are not important and they are not claimed for the design. So, conclusions and comments that we can make about U.S. design practice. Design patents have become more prominent in the U.S., as I said before. Design patent protection in the U.S. is very obtainable and enforceable. but in order to maximize the potential patentability and validity of a design patent, it's important to before filing the application, to prepare the specifications and drawings very carefully. And prosecution of a design patent application is often very straightforward and achievable. So that is the end of my discussion. Thank you very much.
Thank you, Juan. So now we will continue the last section， 也是最后一个段落的部分。最后一个段落呢，是针对我们第二个 topic 里面提到的 Carnegie 案件里面的事实呢，其中提到第二个争点就是辅助性判断因素。辅助性判断因素是在这个非显而易知性判断里面的其中一个element。在美国联邦最高法院那个 Graham vs. John Deere 的案件里面，大家应该很清楚哦。如果说这个案件是几乎是这个判断非显而易知性或我们台湾叫进步性的部分很重要的4个判断要素。那里面有提到这4个原则，那我就不再详细的去描述它。那最后一点里面你可以看到，就是说有提到必须做评估，做出这个 secondary consideration， 也就是辅助性判断因素的证据必须要考量。在我国的这个审查基准里面呢，也是有类似的这个文字描述。那步骤里面 Graham 里面的4个步骤改动，那基本上就是是大同小异的了哈。但我们可以就这个里面步骤的那个详细内容来讲的话，我觉得后面这个修改的这个步骤是比较详细一点的。再回到本案，我们来看到一下，就是就前面这个刚刚提到这个 Graham 或者是我国审查基准里面提到的这几个步骤呢，第一个就是要判断说这个其中一个很重要的一个步骤是判断请求项所记载的发明跟前案的这个差异哈。那因为根据刚刚我们提到的那个案件558专利里面提到的 Lidar， 它是被解释成为脉冲飞时测距光距，然后Mizuno接纳的是利用位置差量测的这个三角测量系统，所以基本上这两者是不一样的。那即便说就是后面的一些其他元件，包含这个发射器在一个高速旋转或者是说有接收器等等这些虽然在Mizuno这边你可以广义的去把它涵盖解释，但是单就 Lidar 这个特征来讲的话是没有被揭露的，也就是这个部分是请求项所载的发明跟 Mizuno 之间最大的差异。我们可以看到下面这个图就是558专利里面它这个装置，它是安装在这个汽车或者卡车上面，可以看得到这卡车它会高速的旋转，它旋转呢，然后那个光的发射呢是朝四周发射，它目标是针对车子的四周的障碍物和环境。那右边的Mizuno呢，它也是有一个圆盘30立方，它也是高速旋转，但是它是往内，然后针对里面这个铜棒的这个外面周围是不是有瑕疵去做测试，而且它测试的方法是在于光接受的位置的差异来去做判断，所以这两者其实是不太一样的。那如果再稍微复习一下右边的图，可以看到入射跟反射的之间它是有一个角度的，它就是经由这位置差来判断是不是表面有瑕疵以及瑕疵的位置所在。所以它接下来就是说既然有差异的，但不代表说没有被完全揭露，这个专利就具有这个非显而易知性。我们还必须判断这些差异是不是可为所属技术领域之人可以依据这个前案的交式的轻易完成。那我们来看看，就是说对技艺人士而言，在阅读 Mizuno 后，他会不会把这个脉冲飞时光测的这个系统运用到 Mizuno 的系统中呢？其实这个也是在该案当中，就是提出专利无效这家公司呢，宽乐举他的主张，他认为是很容易就可以把它运用到这个Mizuno的装置当中，而实现本案这个请求项所载的发明。但是 CFC 的法院是不这么认为的，他的理由是在于就是说，因为这个两者的这个第一个就是 我们可以看到，在本案呢，在它的这个装置安在汽车上面，它侦测的范围是往四周去发射光线，所以它的范围是比较大的。那米猪脑的结构的配置呢，它是往内发射去侦测比较小的产品，而且距离比较短，所以这两个性质上是有一些差异的。那本履技术人员呢，会不会有动机去做这样的修改？这个是第一个问题。第二个问题就是说，那要怎么修改，把它运用到这个车子上面去做探测四周障碍物还有环境的这个量测呢？这也是有困难的那个在 CFC 的判决里面有做一些描述，注明说这些改变并不是显而易知或是可以轻易完成的。所以结论就是，记忆人是没有动机将脉冲、非通时光达应用到Mizuno的短距离测量装置，因为一个是往外朝远的方向，一个是往内量测比较小的物体。那再来就是Mizuno的结构，你可以看到它这个圆盘，然后那个侦测器呢、感测器往内射，这个怎么去运用到把它修改到这个车顶的这个旋转的这样的方式是没有办法交代的。那其实是在修改上有困难。第一点是没有动机，第二个是在实际的修改上也是有困难的。那在接下来呢，除了这个差异之外呢，在美国的这个Graham 它的那个最后一个判断因素就是辅助性判断因素那这边我们稍微讲一下，就是说，在美国的这个判例法里面很清楚的讲说，不管怎么样，一旦有一造提出这个辅助性判断因素，当然通常是专业权人，就必须法院或者是这个行政机关呢，一定要把它列入考虑，不能够就忽略不计但是我们可以看到后来我国有一些判决是认为说是可以忽略不计的，这是差异点所在。那在本案当中呢，这个 V 公司呢，他提出了有很多的这个 secondary considerations。那我想这些包含的就是说这个长久未解决的问题，这个商业上的称赞，还有商业上的成功等等。最常见的应该是商业上的成功那是在这个庭审当中呢，这个专利权人也就是 Velodyne V 公司加他的专家证人，他也去详细说明这些辅助性判断因素跟558专利请求项所载发明之间的这个关联性，他已经满足了这个初步证据就是 prima facie evidence， 已经有大致的说明，而且就是也蛮可靠的。所以 GFC 就推定说，这个商业上的成功跟这个 claim 里面的这个特征之间是有关联性的，就是应该把它列入作为认可非显而易知性有利的因素。那这个就是提出无效的这个 Carnegie 呢，他想要提出个反证，就是说他认为这些商业上的成功，虽然他承认是有商业上的成功，还有一些其他辅助性因素的事实存在，但是他认为这些成功并不是源自于558专利请求项中的技术，他认为是归功于360度的这个旋转视野，还有一个高密度 3D 点状云，用这种方式去做一个反证，去推翻它的推定效果。那我们再看一下怎么，这个就是 CFC 他这边呢，他认为就是说，其实 Carnegie 主张这些特征，它虽然没有说就是直白的就是文字上这个字的描写或是记载在请求项中，但是可以从请求项的右边我们看到红色的特征里面去直接得到的。它这个特征就是 rotating the polarity of laser emitters and the polarity of avalanche photodiodes detectors at a speed of at least 200 PRM。那也就是说，当你这个它这个描述就是说，当这个装置在这个车顶上面用装了非常多的这个发射器而且快速的旋转。那大家知道，就是旋转应该是360度旋转 所以左边那个360度水平旋转，这个其实隐含在这个请求项的特征当中。那至于就是说高密度云，它的这个法院的这个理解呢 ，CFC 的理解就是，当你这个转速用200PRN 的高速旋转的话，它可以收集到的密度当然是很高的，也就是得到的这个点阵云应该是高密度的 dense 3D point cloud。因为在请求项中并没有 dense 这个字眼，但是可以从200转速200 PRN 这个转速里面呢，可以得到这样直接得到这样的结果。所以其实就法院这部分 CFC 是不认可这个 Carnegie 他这边的这个主张想提出这个推翻的这个主张。然后我们再回到这个就是非显而易知性跟这个 claim invention 就是请求项之间的关联性是怎么去判断这边来稍微简单解释一下，就是说，如果说商业上的成功可以归功于 claim 里面的特征 A 跟 B， 但是这个 claim 里面呢，除了 A 跟 B 又包含了 C 跟 D， 但是只要说技术特征 A 跟 B 已经有记载在请求项中，就可以做出这样的推理。因为 CD 是不重要的它有没有记载其实没有关系，并不影响。这个是从这个法院判例里面得出来一个结论。第二个结论就是说，但是相对的，如果有一项产品的商业成功是 A 跟 B， 但是只有 A 记载在请求项中 ，B 没有的话，那这样子的话就没有实现它的这个确定的关联性所在。那在接下来我们来看一下这个我们比较一下台中美辅助性判断因素这边做一个表列了当然美国这边它列的是最多的，而且其实它这个所列举并不是一个那个排他性的这个列举那我们可以看到就是说商业上的成功还有不可预期的功效，这是不管是我国大陆或美国都有，解决长期存在的问题这个也都有，还有克服偏见这也都有。但是他人的失败有人抄袭以正文献的不可操作这些的话呢，在美国是有明文规定在他们的 MPEP， 但是在我国的审查基准或是大陆的审查指南是没有的。那我可以讲就是说这几个辅助性判断因素里面呢，最常见的是还是这个商业上的成功，还有这个其实是可预期的功效的部分。那我们来回过来看一下我国审查基准里面，它有提到就是说，判断进步性的时候，如果申请人提供了这个辅助性证明资料支持进步性时，应一并审核，就是只要专利权人这边或是申请人有提出的话，就一定要把它考虑，不可以把它忽略掉。这个也是跟美国实务上是一致的但是我们看后面有一些我国的早期判决，有一些是并不是这么认为。那在这个审查基准里面有提到，就是说他有提到说，商业上的成功必须是直接由发明之技术特征所导致，而非因其他因素、销售技巧或广告宣传所造成。那这个其实造成针对这个专利权人蛮大的负担，他必须要去证明说，它不是因为销售技巧或广告宣传所造成的。那这种其实因为商业上的成功因素是非常多的，这种举证其实对专利权来讲负担是相当的重，所以造成我国这个可以经由这个辅助性判断因素来把这个案件翻转的这个，或是作为有效这个因素的案例就会变得比较少。我们后面会做一些来讨论。像在这个案例里面，它里面就是说，因为就是经过比较以后呢，跟被证235比较，经明显不具进步性，自无辅助判断之必要。那很显然就是跟现在这个实务上不管你怎么样，只要对方只要是专业权人提出的话，就必须去做一些分析和这个考量是不太一样的。那还有另外一个案件里面有提到，就是说他这边有提到说，不能够仅因为市面上相反的手电产品多寡来 论断说它具有商业上的成功等等。所以这个就是我们刚才提到，就是说必须事务专利权人必须要证明说，他也必须要排除其他的因素，才有办法去主张这个辅助性判断因素。那这个判决也是，就是说就是它里面提到，就是说无从确认替身专利制作的商品有何种程度的商业上成功，这也是类似的，因为要专利权人去举证说他的这个商业上成功没有任何其他这个销售的宣传手段牵涉其中，其实是有困难的。那另外一个判决其实也是有类似的情况，就最下面有提到，就是说不能排除因销售技巧、广告宣传、市场供需型整体社会经济等因素所致。这样子讲的话，就专利权人就很难去举证了，因为他要去做这样的举证，其实是蛮大的困难的。但是我们这边看到一个案件，就是说他这边有提到商业上成功有被列入考虑的是，因为他第二代的产品呢有被仿冒，第一代没有被仿冒，然后第二代的产品有第一代没有的特征，所以他就可以证明说是因为第二代的产品的这个特征造成它商业上的成功。这一部分是在这个案件里面有被认可，这是我找到少数有几个在我国判例里面商业上成功有被列入考量的这个案件之一。但我们也就是各位也可以清楚了解，就是我国的专利实务其实相当一部分是跟美国的这个实务是有所遵循的。那我们可以预见，在美国这个案例里面，特别近期我发现就是由于这个发明的数量越来越多，那必须要用一些商业上的成功的辅助性判断因素来证明它的这个可专利性。那而且就是在美国这边也慢慢发展出一些系统来去认定这个商业上的成功，或者是其他辅助判断因素是不是可以列入考虑。那我觉得慢慢的在我国这部分也会把它这部分列入，因为这个是一个应该是会是一个趋势因为你现在发明越多，我们可以发现越来越多的发明，它可能很多都是高度的创新性。那如果说只要可以它证明上它在商业上确实是有所贡献的话，是必须要考量。那我想就是我们今天报告的时间就做到这里。那我这边要讲就是说，如果说贵公司或者说你们的这个专利有在美国申请的话，因为有提到就是其实刚刚Juan那边的那个设计案例里面有提到，在辅助性判断因素里面对你的这个案件维持有效其实是有帮助的。所以如果贵公司或者是你个人的这个发明在美国有一些商业上的行为，或者是有申请专利的话，一些辅助性判断因素，比如商业上销售成功等等这些证据，也许你们可以考虑要把它保留下来以备不时之需。这是我个人的一个小小的建议。那在接下来的时间里面呢，我们会进入这个就是可能稍微早一点点的结束我想把这个时间留给这个听众，如果说有一些问题的话，我们可以提出来。那这边可以做一定的这个来去做回应部分。当然也在线上，所以如果有任何问题的话，也是可以去做出一些问题的。那我想这边第一个就是说，看到有一个问题就是其实由于美国跟我国这边包含了就是在亚洲国家这边在就是这个法律制度上面是不太一样的，因为在美国这边它采的是这个case law， 或呢在整个审判系统也不太一样。那在我这边基本上就是由法官这边来去做判决。 那当然现在也有一些这个所谓的三审制度，但是现在目前为止还没有很完整的发展出来。那在美国的这个专利实务这边呢，会有一些这个会做一些区分啊，就是法官是负责法律的这个部分，那事实的部分是交由 jury 哈。那我看这边有一些我这边有一些问题，就是说关于就是 maybe we have a question for Juan that we know that in the U.S. court systems that jury plays quite an important part in U.S. court cases, such as the famous case that we know recently, Johnny Depp versus Amber Heard, that the jury's decision is critical. Maybe Juan, you can briefly introduce your jury system, especially for patent litigation cases. Briefly, just give me some outline, maybe 5 minutes. Juan, can you give us some introductions about your jury system for patent litigation? I will switch the control to you.
I'm sorry. If the question is a general overview as to how patent litigation is handled in the United States, okay, like all other cases in the U.S., a patent litigation does allow a jury trial. Okay, it is something that the parties can request to have a jury trial, but after obviously a complaint is filed and the defendant or potential infringer answers, basically we go through discovery where both sides will try to obtain information about each other, primarily what the infringing products are, how many there are, what patents they're relying on, all that kind of information. And unlike other court proceedings, in patent litigation in the U.S., there is called a Markman hearing, which is where both sides will discuss their interpretation of the claims in the patent, and then the judge will decide what interpretation of the claims they will use, if any part of the claims or any interpretation of the claims are being disputed, or they're not in agreement between both sides. And then after that, then we will have a trial. As I said, typically they could be both by jury and by judges. At the end of it, at the end of the trial, you then have a determination of whether or not the patent or patents are infringed, and then there will be a decision as to how much the damages are going to be, based on usually the number of infringing products, the sales, and whether or not the infringement by the defendant was willful or not.
Thank you, Juan. So the damage amount is determined by the jury. Is that correct?
Could you repeat the question, please?
In the patent litigation cases, the damage amount is decided by jury, not the judge.
Correct. That if there is a jury present, then the damages can be made by the jury.
Okay. In the Markman hearing, the claim construction issue is determined by the judge.
Yes, that is determined by the judge. It is considered a matter of law.
Yes. Now we have another question that is on my part, so I will switch the control. 好，这边有一个问题是关于后见之明或hindsight是否可当作进步性的答辩理由。其实这个就是我们在答辩的时候是蛮常会讲到这一句话的。那这边这个是有一些就是结论性的这个陈述了哈。那在整个答辩的过程当中，还是必须要优先以这个Graham vs John Deere 它这个4个这个步骤里面，第一比较这个 claim invention 跟这个先前技术的差异，然后第二步骤再就是这个差异是不是显而易知？那这个是不是显而易知，当然就是还包含了是不是有动机去把它组合的哈。那当然最后就是说，我们可以就是根据以上这些分析，可以知道说，我们认为就是审查委员或者审查员对这个不具进步性的结论，应该是基于参考过说明书之后得到的后见之明。那这个是有加分的作用，但是我们认为一般答记不行的时候，还是要比较它的这个claim invention 跟这 prior art 之间的这个差异，以及这个结合的动机的部分。特别你可以去利用一些，如果说这个 prior art 里面它有一些教示呢是 teacher way， 就是这两者的结合的话呢，是可以会更有效。当然后见之明这句话是通常我们也是会用上的，不知道有没有这样子，也没有回答。然后再接下来我看到另外一个问题就是说是关于这个辅助性判断因素在美国的案件当中成功的这个比例大概是多少？ Hi Juan, so we have a question is that according to our experience that the chance that the patentee relied on secondary considerations to win the case, the chance of success, according to your experience, that is high or low, or any idea?
Okay, if the question is, what are the chances of success in litigation if you are relying on secondary consideration?
Right.
It will depend, of course, on what kind of secondary consideration. Okay, secondary consideration are usually things like commercial success and long-felt need. If you are able to develop, good evidence of commercial success or long-felt need, then it can help win a case. Okay, it can. But the problem is when you are already doing secondary considerations, you have already given up the other issues, which are anticipation and prima facie obviousness. Okay, basically, if you are already using secondary consideration, the evidence before that is already suggesting that your invention was obvious, and you are just trying to use the fact that you are able to sell your product better, or that your product or your invention served a need that no one had done before, even though in some way there was already prior art very, very similar to your invention. It means that your case is potentially not very strong already. So it has to be very strong secondary consideration evidence.
我们现在看起来好像没有新的问题。So if we do not have additional questions from our audience, maybe 所以我想可能也许就谢谢各位今天的参与。如果会后如果有任何问题的话，欢迎直接把你的问题 email 到Juan的 email address 或者是我这边的 email address。那我们会尽量来去跟你提供相关的服务。那就谢谢各位的参与。Thank you, Juan, and thank you for the audience participation for the webinar.
Thank you very much.